attempted exemption fails. Generally, this leads to the opportunity for the purchaser of the security to bring a civil action under Section 12 to rescind the purchase. In such an action, the purchaser could recover the purchase price paid for the securities, or if there was a previous sale of the securities, any damages suffered during that sale of the securities, along with any interest from the initial time of purchase. So again, this is commonly referred to as selling a put, because when you sell the security and it's subject to this type of action, then you're actually allowing the purchaser at any point in time to force you to repurchase the security from them, or as I described before, pay damages suffered as a result of that. So it can be completely detrimental to the issuer to have to refund the money taken in during the issuance. Now, there is certain protections in place for issuers who run afoul of rule-based exemptions. Generally, if the issuer can show that the deviation was not extreme, that it was simply a minor procedural deviation from the rules or requirements that caused the exemption to fail, that the type of protection sought under the exemption was not the type of protection intended for this type of purchaser. That is, say, the rule-based exemption focused on protecting non-accredited investors. Well, if they can show that an accredited investor was the purchaser and they were not the type of investor sought to be protected under the exemption, that could be a justification. And if you can also show that you tried in good faith to comply with all of the exemption procedural rules or requirements, then if those three things are present, then it may be a defense to an action by a private investor to rescind the purchase, or in a civil action by the SEC to in some way charge you with liability for violating the requirements of Section 5 to register a security before selling.